Mr. Speaker, we are opposing this bill for a number of reasons. Number one, Panama has an established, clear, and absolute long-standing reputation as a tax haven for tax evasion and tax avoidance. Second, Panama has a history of military dictatorship. It has a poor record of labor rights, human rights, and the deal side agreements for both labor and the environment are, as I will delineate, very weak. We are also very concerned, third, that the agreement provides greater rights and powers to foreign investors. This is worrisome given controversies on the environment and human rights records of some Canadian mining firms in Panama. There are no penalties for environmental violation of this agreement whatsoever. In other words, if there is any single violation or multiple violation of the environmental side agreement, not one penny is provided for in this agreement to be levied in terms of fines or penalty. In other words, the environmental side agreement is suggested only. I'm going to deal first with the tax haven situation. Mr. Speaker, the amount of money invested in tax havens in the world globally at the moment is at an all-time high. In 2011, almost 25% of Canada's investment was invested in the world's top 12 world's tax havens. According to a Justice Network report from 2011, Canada loses an estimated $80 billion per year to all forms of tax evasion. The government does not have a system for estimating and publishing the amount of lost revenues due to offshore non-compliance. In 2011, there were more than 9,000 CRA employees working on taxpayer compliance. As of May 2012, 510 were assigned to the International Audit Program. That number has not changed since 2008, even though the use of offshore accounts has skyrocketed. The CRA's 2010 audit of its own enforcement branch confirms the agency's inability to pursue complex offshore cases worth millions of dollars. Instead, it prefers to chase down the so-called low-hanging fruit, such as small business and the self-employed. Now, Panama, as I said, has a long history of serving as a tax haven. Here's some of the testimony that we heard at committee in 2010 by Todd Tucker, who's a research director of Public Citizens Global Trade Watch. He testified that Panama offers foreign banks and firms a special offshore license to conduct business there. Not only are those businesses not taxed, but they're subject to little or no reporting requirements or regulations. According to the Organization of Economic Cooperation and Development, the OECD, the Panamanian government has little to no legal authority to ascertain key information about these offshore corporations, such as their ownership. Panama's financial secrecy practices also make it a major site for money laundering from places throughout the world. According to the U.S. State Department, major Colombian and Mexican drug cartels, as well as Colombian illegal armed groups, use Panama for drug trafficking and money laundering purposes. The funds generated from illegal activity are susceptible to being laundered through Panamanian banks, real estate developments, and more. Mr. Speaker, a recent Cornell University study analyzed all prosecutions over a 10-year period of the Internal Revenue Service of the United States, and it found that Panama was tied as the #1 country in the world as a source of drug laundered money and as a source as a tax haven. Now, there was some testimony at committee that the situation was so-called improving. Recently, Panama was removed from the so-called OECD gray list after implementing the standard for exchange of information when it signed a tax information exchange agreement with France. Panama now has 14 such agreements. In March 2012, Canada and Panama entered into negotiations of a tax information exchange agreement. However, importantly, Mr. Speaker, and critically for the opposition, this agreement has not yet been concluded or signed. This is very troubling considering the large amount of money laundering in Panama that I believe no one in this House disputes, including money from drug trafficking. Panama's lack of taxation transparency has led the OECD to continue to label the nation as a tax haven. I should point out that the so-called grey list, Mr. Speaker, is lifted from a country when it signs tax exchange information agreements with 12 countries. But notably, former President Sarkozy of France said, notwithstanding that Panama had signed more than 12, in other words 14, such agreements, he still did not consider Panama to have entered the legitimate world of open, transparent banking systems in the globe. Now, at committee, I questioned the government officials that testified about what due diligence Canada has done in determining the role of drug money in Panamanian banks and businesses. Astonishingly, they had done no study. Cameron McKay, a DFAID official, testified thus: "We don't have figures in that regard, and to my knowledge, the Canadian government hasn't done any particular study. But we are all well aware, of course, that Central America is a region now that's suffering very seriously from the narco-trafficking trade. It's a serious issue across the region, including in Panama." That's from testimony on October 2nd, 2012. The U.S. Congress refused to ratify a free trade agreement with Panama before signing a tax information exchange agreement. According to witnesses, this agreement has, quote, "a large loophole that allows Panama to sidestep tax transparency provisions if they are contrary to the public policy of Panama," end quote. Analyses of these agreements, these tax exchange information agreements, indicate that they are highly ineffective in preventing legal tax avoidance or illegal tax evasion unless they're carefully drafted. These agreements typically do not have an automatic information sharing provision. Rather, individual requests must be made. Furthermore, they generally do not require a partner country to provide information necessary for determining tax compliance in the other nation if it has not been previously created. In particular, it is typically necessary to know the name of the individual suspected of tax evasion to request the overseas tax information. Governments rarely have this information without a whistleblower. Now, prior to the clause-by-clause review of Bill C-24, the NDP official opposition proposed to the committee a motion which would stop the implementation of the Canada-Panama Trade Agreement until Panama agreed to sign a tax information exchange agreement, like the U.S. Congress did. My motion was defeated by the Conservatives and the Liberals, who argued that progress was being made on this matter with regard to negotiations underway to sign an agreement. However, we do not have a tax exchange information agreement between Canada and Panama today, as we sit and vote on this free trade agreement. So in other words, we're dealing with a noted tax haven, one of the most notorious drug laundering centers in the world. U.S. Congress said that it would not be safe or prudent to sign a free trade agreement with such a country until they first had a tax exchange information agreement in place. And yet in this House, the government is asking parliamentarians to go ahead and give most favored nation status, free trade agreement that will allow money and investment to flow with very little barriers between our two countries, when we do not have a tax exchange information agreement in place yet, but one might happen in the future. Mr. Speaker, that's imprudent, that's irresponsible. The U.S. Congress would not ratify their FTA with Panama before a tax exchange information agreement was signed. Why are we? Now, I want to talk a bit about the Labour Cooperation Agreement. It's not as strong as it could be. It has weak enforcement mechanisms. It invokes the International Labour Organization's core labour standards. However, according to testimony we received at committee, the agreement does not include specific protection for the right to organize and the right to strike. It provides instead for what so-called effective, end quote, recognition of the right to collective bargaining, making this deal weaker than others Canada has signed. Enforcement is weak, fines are small, there are no countervailing duties, there's no provision for abrogation or any other such remedy. Now, interesting, Mr. Speaker, we heard a lot of testimony that what Canadian business wants is a level playing field. Well, I questioned experts and witnesses at committee and asked what the minimum wage was in Panama. And the answer I got was between $1 and $2 per hour. How is that a level playing field for a Canadian employer in Canada who has to pay minimum wages of at least $9, $10 an hour, workers' compensation benefits, health benefits for their employees, Canada pension plan benefits, has to comply with a whole bunch of regulations that are part and parcel of a modern industrial economy. And they're supposed to compete on a so-called level playing field with the Panamanian employer that's paying their workers $1 to $2 an hour? Mr. Speaker, that is not a level playing field. It's not fair to Canadian business to sign and attack a trade agreement with a country that has such low standards. The agreement on the environment, as I've said, is a replication of environmental agreements we've signed before and doesn't provide for a single penny of penalty. What kind of agreement is there when you sign an agreement with another country that obligates it to certain environmental standards, but if they violate them, we send them a letter? We admonish them? That's irresponsible. A quote from Jennifer Moore from Mining Watch. Although this agreement includes an environmental side chapter, this is a non-binding declaration that relies on political will for its implementation, of which sort we have not seen in Panama. On the contrary, we've seen the undermining of environmental protections at the behest of Canadian companies. Mr. Speaker, this agreement has an investor-state dispute settlement, something that we've heard a lot about in this House over the last 2 weeks because one is contained in the Foreign Investment Protection Agreement with Canada and China. This deal will further entrench the ability of companies to sue governments for policies that are seen to hurt investments. They are administered through tribunals that do not live up to Canadian values of justice, where the judges do not have security of tenure and there's no effective appeal mechanism. In fact, there's about 60 international lawyers around the world who sit on these tribunals, and one recently said that he could not believe that any country in the world would give over to an unaccountable panel of 3 lawyers the power to strike down their domestic democratic legislation. And that's exactly what was said. Now, these investor-state dispute settlement mechanisms, Mr. Speaker, are very dangerous. We've seen in the FIPA that they could subject Canadian taxpayers to millions, perhaps billions of dollars of liabilities, simply for their government taking measures to protect Canadian business or the environment or social programs. And that's wrong, Mr. Speaker. In terms of the environment, there's a Mesoamerican corridor in Panama that is one of the most important biological and biodiverse areas of the world, where currently there's a worldwide attempt by mining companies to mine in that area. This is something that's very concerning to many environmentalists, where hundreds of different types of species are at risk through unrestricted mining activities, and we heard testimony at committee that this is also of major concern. Now, Panama accounts for less than 1% of our trade. Actually, Mr. Speaker, Panama accounts for 0.03% of Canada's trade. Now, the government always brags about the number of agreements that they sign. They've signed 9 agreements. You know with who? Panama, Jordan, Colombia, Honduras, Liechtenstein. Now, these are with great respect to these countries, not major economic powerhouses in the country. What the New Democrat opposition wants is a strategic trade policy where we restart the multilateral negotiations, where we sign trade deals with developed countries that have high standards and developing countries that are on progressive trajectories. Companies like Japan, like India, like Brazil, like South Africa, like the BRIC countries. These are the countries that we should be signing trade agreements with, not countries like Panama that are drug laundering centers, tax havens, and have low standards that will hurt Canadian business. Thank you, Mr. Speaker.